Good morning, everybody. This is a Government Operations and Fiscal Policy Committee meeting, July 19th. We have two important items today. We do have Bill 1921, Finance, Reports on Settlement Agreements, and we also have a discussion on additions to the Office of the Zoning and Administrative Hearings Comprehensive Fee Schedule. And first, let me say that I do want to thank Councilmember Jawanda for introducing this bill. We have received a number of amendments, both from our administration as well as community advocacy groups, such as the Silver Spring Justice Coalition, as well as Jews United for Justice. And I think this is a bill that will continue to enhance our ability for transparency and important information sharing for our community, because after all, when it comes to settlements, we're talking about taxpayers' money, and it is important to understand exactly what is going on and what are the circumstances, etc. This bill requires the county attorney to periodically report to the county executive and county council regarding settlement agreements entered into by the county, and requires the county attorney to publish each report on the county's website. But as I said, there are other amendments that we will consider today. The lead sponsor is Councilmember Jawanda, and co-sponsors we have Council President Hucker, Councilmembers Glass, Reamer, Rice, and Navarro. And this was introduced on May 18th, 2021, and we did have a public hearing on June 22nd. So with that, let me remind my colleagues that they can text me or just raise their hand. But let me, before I turn it over to Ms. McCartney Green, which has prepared a really wonderful packet, let me turn it over to Councilmember Jawanda for some opening remarks, since this is his bill.
Thank you, Councilmember Navarro. It's great to be with the powerful GO committee, and good to see my colleagues. So you teed this up well. I just wanted to add a couple of remarks of context, and really appreciate all the co-sponsors, including Councilmember Navarro and Glass, Rice, Reamer, and Council President Hucker for co-sponsoring this legislation. It's really aimed at a important premise, and something that we've been working on here for this entire council, really, is how do we improve the strained relationship between not only law enforcement, but anyone in government who's charged with protecting and serving and providing for the public, and improving that relationship, because only when we have trust will we have efficient and effective government. And you need transparency to have trust, just like in any relationship. And we have to be really honest with ourselves about what's happening so that we can address it. You know, we're a great county. We have great men and women who are serving our residents in a number of capacities, including law enforcement. But we know that things don't always go the way we would like them to go. And unfortunately, we've seen that over the last couple of years here in the law enforcement context, which is one of the prompts for this bill. But it's our responsibility as council members to hold our government accountable and to improve. And in order to do that, you have to know what's going on. You have to have an early warning system. You have to have systems in place to know where the problems are or might be and what happened, so that we can learn from them. And you do that through transparency. And if we're going to reimagine public safety system, we have to know what's going on in the context of policing. So this bill will set a new standard for that, give us another tool in the toolbox to understand what's going on. As was mentioned, the county council and the executive will receive a public report on all financial payment settlements that the county agrees to settle against its employees. It's including but not limited to our police department. And as was also mentioned, these are taxpayer dollars. So it's a direct cost and you know, we can't be worried about, oh, we don't want something to come out about the county that we didn't act wrong. We should own up to it and improve. And that's what this is. We just last week we learned of a $400,000 settlement paid to Mr. Arnaldo Pessoa, who was the young man who was on the ground, handcuffed, and violently kneed in the neck by a Montgomery County police officer. The officer was subsequently charged and convicted of assault. And this had consequences, long-term consequences for Mr. Pessoa in terms of damages to him and also to the county and to the trust relationship between our law enforcement and our community. And so this is one incident that we've heard of because it was a high-profile incident, but there are others. And we need to be able to examine if there are patterns and what is happening in the public deserves to know this information as well. So we've done a lot of work to improve police-community relations. This is another step that's not just good for that relationship, it's good for the entire government. And so I really appreciate all my colleagues that have co-sponsored. And I know we have some great additional amendments that we'll discuss. And I look forward to joining for that discussion as well. So thank you, Councilmember Navarro.
Thank you, Councilmember Joanda. Okay, so with that, I also want to welcome Mr. Mark Hansen, our county attorney, and I think I also saw Mr. Mark Oz here as well. With that, let me turn it over to Ms. McCartney Green to walk us through the packet. And also what we'll do is that when we get to decision points, if you can just pause, let us know, and then we can engage in a discussion and then see where we go with those. And then of course, when it comes to the amendments, likewise, and thank you for preparing the addendum that does include some amendments that were forwarded by some of our community partners as well, and we will consider those and dispose of those as well. Thank you.
Thank you, Chair Navarro, and good morning, Councilmember Katz, Friesen, Wando. So it's a pleasure to be able to walk you guys through Bill 1921 packet. As you mentioned, we do have two attendees here today, our own County Attorney, Mark Hansen, who's going to be able to answer some of your questions or comments, and also joining him is John Marcos. With that being said, I think you've already laid out the intent of the bill and the bill specifics, but I will specifically go through a couple of discussion points that came up either through public comments or researching the bill and looking at some of the legalities surrounding it. But essentially, the bill would require periodically reporting, and not only just reporting, but publishing on the website. So I have the packet open, and I am going to be on page 2 of my staff report and kind of start there and then just work my way through. And as you mentioned, Chair Navarro, I'll stop and take any questions or comments. So the first question that came up, really, from the public and just researching is, are settlement agreements confidential? Are they non-disclosable? And what does the law have to say about that? And so generally, state law under the Maryland Public Information Act is that the public has a right to the government records. There are some exemptions, though, where certain information can be redacted or exempted. And that's specifically under the General Provision Code 4301. I've listed a few. Some of the main ones are adoption records, medical records. Personal records has come up quite a lot, especially when it comes to law enforcement. And then the court can also make an order exempting some of that information. But overall, settlement agreements are disclosable, and they are considered public records. The Maryland Court of Appeals has had a few cases where they've come out and says private contracts are not valid, and we shouldn't rely on confidentiality clauses to exclude them from the public. With that being said, I did have a decision point here where the committee could consider language of adding that the county attorney must adhere to any exemptions that might be in violation of the Maryland Public Information Act. I think this would strengthen it. I don't think it takes away. Either way, we are preempted providing information that is exempted. So if the committee wanted to go ahead and strengthen the language by putting it in there, I think that would be definitely fine. But either way, if we are producing anything on the website, we still have to abide by state law. So I'll stop there and continue if you want or further discussion.
Let me see if my colleagues on the committee have any objection to that language that was suggested. Okay, without objection, we will accept that language, and since it's strengthening language, thank you.
Okay, sounds good. Moving along, so the next question was that if settlement agreements are disclosable under MPIA, why not take that route? Why implement legislation to require the county attorney to do that? And some of the feedback is that it takes a while, right? It may not be readily available for the public, and that just the time consumption of going through that. So I looked at, what the MPIA, what's the requirement? And so the agency is expected to do it fulfill the request within 30 days. But there are instances where it does not meet that 30 days. And so Bill 1921 would require that annual report to be available for taxpayers and to prove regular oversight and accountability. So that's just more informational of just asking the question of why, putting this in legislation is now there be an actual requirement. And so then I looked at going to number 3, I looked at what does the county attorney do now? What are they providing to the public now? And where does that align with this bill? So the county attorney's office, publishes quarterly reports with aggregate data of settlement agreements or claims from its website. However, if you look at it, and I circled page 20, it's very basic in nature, right? It provides just the name, the case type, and the status. And so it doesn't give very specific details. So Bill 1921 would require a little bit more transparency regarding the data collection, requiring that report, listing the claimant's name, listing the settlement amount, listing the nature of the claim, and it's also a searchable single point of access, as we mentioned, for the public. So that's just to give you a preface of what's happening now and where things may be strengthened through Bill 1921. I'm going to stop there. Any comments or questions, or should I continue? Okay.
Continue.
And so the next thing that I looked at is what are other states and cities doing? Have they adopted a bill similar? Is Maryland a standalone? Are we the only one asking this? And what I found that's not true. There are other states that are looking similarly internally at their records and what they can improve. Specifically, I highlighted Nebraska, just because their language is a little bit tailored to what we had, and looking at the process that they kind of built. And really the governor, signed the law and really said the goal of it was to make it easier for the public to be aware of costly legal settlements. Very straightforward, very transparent. But what Nebraska did, it's a little bit different from 1921 language, is that, and I'm looking at the indented section that I have there, it's for the record of all such claims settled in the amount of $50,000 or more. So they did narrow it based on the amount of the settlement claim. Now, as you know, Bill 1921 doesn't do that. It's broad. So I did put that there for the council to look at to see if that's something that made a difference. But there are other states, and I thought Nebraska was one of the ones to highlight because their language also required to include brief description, the parties' names, the amount. The only thing that's a little bit different was that they based it on the settlement amount of $50,000 or more, or 1% of the total annual budget of the public entity, whichever one is less. Okay, so more the bread and butter of really looking at the amendments from the county attorney, and I know Mark is here also to supplement any information that I provide and answer questions. But in his testimony, so there's no legal issues with the bill. This is the first thing just to kind of clear. But the first amendment that was suggested was to narrow the class of claims subject to reporting of civil rights claims only. And that's a violation of the U.S. Constitution, the Maryland Constitution, federal, state, or the county civil rights law. Testimony is provided there. In addition, I think there was also, so just to back up, looking at Mr. Hansen's testimony and realizing that the aggregate numbers of workers' compensation claims, looking at the aggregate numbers of debt collection and code enforcement, and looking at whether or not that was serving the interests of this bill and whether or not that would be an omnibus reporting, council staff did agree that there should be some type of filtering of what do we really want the substance and the crux of the report to be. And, looking at there is a heightened public interest to report civil rights claim, no doubt. But also looking at what is the county attorney already doing? So they are tracking claims that include self-insurance funds, such as constitutional rights, common law torts, employment discrimination, medical practice, ADA claims. And so recommendation, at least from my perspective, was that all of those should be included in the reporting as what they're doing right now. Now, this is not obviously in line with what Bill 1921 does right now. It basically requires all claims. And so that's something for the committee to look at. Do we want to consider, does the committee council want to consider all claims, or is there a way to narrow it to what we think would be of public interest? And I'm going to leave that just for a discussion and for weigh-in from the county attorney's office. That was also amended.
Okay, Mr. Hanson. Mr. Hanson. No, you're Hanson.
Sorry, I had to get myself unmuted here. There are so many buttons to push and so little time. If I might, just before I address the issue that is in front of you, I just wanted to, if I could, go back for a second to the amendment that the GO committee approved regarding confidentiality. And I just wanted to suggest maybe a technical amendment to that proposal, and that would be that there are other laws than the Maryland Public Information Act that requires the government to maintain confidentiality. In the family law article regarding juveniles, there's federal laws involving students, and that we have to respect confidentiality for. And so I would just suggest that the amendment reads something that we have the county attorney must adhere to the exemptions of reporting any public records that may be in violation of law, including the Maryland Public Information Act, so that we would have cast a broader net to capture all of the laws that require confidentiality. So it's just a technical suggestion. So I would leave that to your discretion as to whether you wanted to adopt that or not.
Let's see, Ms. McCartney-Green, do you have any thoughts on that since it wasn't included in the packet?
Yeah, I have no objections to that, and happy to make that more of a broader net. That's fine.
Okay, so that's a friendly amendment. Councilmember Jawanda, you have you raised your hand. Go ahead.
Well, yeah, just on this point, before we move to the current one that we're on, Mr. Hanson, I understand why you would say that, and I think functionally, whether we included the language or not, as Mr. McCartney-Green said, that would be the case. You'd have to abide by that. But I do think it's important, to be transparent about what we're not including, right? So if there's a way to, I think maybe as you do this report for the first time, to list the reasons why certain claims might not be included, like some of the things you just rattled off. There could be a juvenile. There could be some sort of MPIA violation. I just think so. We're saying something to that, and then also I'm assuming obviously you'll comply with. There's obviously a change, for example, in the MPIA law as far as personnel records being disclosable by the custodian under the action that the state took, and obviously you'll take that into account. But
absolutely.
So just a suggestion, as I don't, not on the committee, but obviously I think that language is fine, but I would just recommend that we just acknowledge that, say it maybe when this report is done, that these are the reasons why there might not be some claims.
Agreed.
Yeah.
Okay. So I think without objection, the committee would welcome that. And I think it is important, especially because the public may not, fully have the information as to why these are exempt. And I think listing them or providing some kind of reference to that would be helpful for sure. I think it's a very good addition. So we'll do that.
Back to the issue at hand. If I understand council staff's suggested narrowing of the scope of the bill to cases or settlements involving basically the county self-insurance fund, which would involve claims for monetary damages on the basis of allegations that the federal or state constitution had been violated, a state, federal, or county civil rights statute had been violated, or if a common law tort had been committed by a county employee. And I think that's fine. I think that addresses the major concern that I had, which was the bill as introduced cast such a broad net that it would have included workers' compensation cases, code enforcement cases, debt collection cases, grievances, contract disputes, which seemed to be somewhat attenuated to the main purpose of the bill and would have imposed, I think, a significant burden on the county attorney's office. It would have required additional resources in order to, tease out all of that information. So I think that as I understand council staff's suggestion, it makes sense to me.
Councilmember Friedson.
Thank you. I think it's a good amendment. I think that it makes sense. It keeps the intention of the bill while being more reasonable with the expectation in order for the public interest. I'm just curious if we approve this amendment, is the additional staffing that was suggested as part of this? Obviously, we don't vote here on a bill based on staffing, but would that address the need for additional staffing if we are, significantly reducing the burden on the office?
Yes, it would address that issue.
Okay, I think it's all the more reason to do this. I didn't think that, based on the intention of the bill, why there would be a need for additional staffing. I understand if, the scope is so broad as you mentioned. So for both reasons, I think it would be, it would be in the best interest of the public for us to move forward with that. I'm glad to hear that you're able to do it within existing resources if we focus in on what the intention of the bill actually is.
Councilmember Jawarman.
Thank you. Yeah, and I really appreciate council staff's suggestion here. I was a little concerned about what would civil rights, and I felt that to be a little too limiting, but I think stepping maybe half a step back to include all the self-insurance claims, which include the things you talked about, the common law tort, and is the intent of the bill. While there might be other reasons to know where we're having the most workers' comp claims in the GO committee, I don't think this is the intent of that bill. This is the intent of this bill. So really appreciate that. And I did just have a question for Mr. Hansen. If you don't know it, you can get it to me later, but maybe before we get to full council, is what is the average amount of self-insurance? Last year, how many self-insurance claims, what was the payout? How many, you said this isn't a significant burden, can you give us a sense over the last couple of years of what is generally being paid out? Or how many claims, or let me rephrase, forget the number of how much is paid out. I do want to know that, but you might not have it. About how many claims under the self-insurance fund do we have a year, roughly, average?
That I do not know off the top of my head, because the whole universe of claims would involve the claims the self-insurance fund through its third-party administrator, Corvell, resolves. So there are, for example, if you got rear-ended by a bus and it was relatively minor damage and you wanted compensation for repairing or replacing your bumper,
that falls into that as well.
That falls into that as well. And what happens is that those claims are handled by the third-party administrator, just like insurance adjusters. And they would call it, once we got notice of your claim, they would call you up and say, okay, what happened and what your damage is? Can you give us send us the bill for the repair of the bumper? And they would settle the claim. And so the county attorney's office doesn't see that universe of claims. We
Right.
see, when the matter can't be resolved by the third-party administrator, then it perks up to the county attorney's office once a lawsuit is filed, and then we become involved.
So,
And
but
that universe is relatively small.
right, and that's what we're talking about here. These are claims settled that are settled because of lawsuits.
Yeah, right. That's what we're talking about.
Right.
Exactly right. And that amounts to probably if one of the attachments in Ludine's packet showed that the last, I think, 2 or 3 years of settlements, I think the highest number was 30. And sometimes they're, 10 or less in a year. It just varies.
Okay, got it. So this is a knowable universe, and we'll be able to look over time and have additional information. Okay, thank you, and I appreciate the recommendation from the council staff. Thank you, Madam Chair.
Ms. McCartney-Green, can you restate your recommendation again for the public's interest?
Yes, definitely. And so the amendment here is for Bill 1921, requires the county attorney to disclose all settlement agreements, regardless of the nature of the claim. Today, the committee has agreed or will consider whether to narrow that to include constitutional rights violations, common law torts, looking at civil rights violations as well, and which will include ADA and any employment discrimination as well. So narrowing it to the self-insurance fund claims that are already being tracked by the Office of County Attorney. I hope I made that clear.
Yes, thank you. Okay, and so I saw a lot of nodding from my colleagues. Councilor Katz, you have something else to add? Go.
I do. I never know to say I'm agreeing and shake my hand, or say I don't have a problem and say no. I mean, I'm fine with what is being suggested. My only question is about the term self-insurance. If it goes to another insurance carrier, I mean, I know that we have self-insurance, and then over and above it's another insurance carrier, or at least we used to be able to do that. If it goes to them, are they bound to disclose their settlements? How does that happen? Not the third party who's working with self-insurance, but if it goes to another insurance carrier.
Yeah, that's a very good question. Mostly, the county is essentially self-insured for the first $3 million of liability. And so the county attorney's office handles those cases. If it looks like a case might go above that for some reason, the excess line carrier is what we call it, starts tracking the case, and they ask for a whole bunch of reports, but the county attorney's office would remain involved in that case. We wouldn't be able to settle the case above $3 million without getting the carrier's consent, but that would still be, if we were to settle it, would be caught within the net of this bill, and would be it would show up on that report. There is, you do raise a question that I don't know technically the answer to off the top of my head. We do have insurance for the fire department, and it's a I forgot the name of the company, but we don't have a deductible in that case. That insurance company picks up the case the moment we get sued. Mostly they are automobile accident cases, but occasionally we do get an employment discrimination case, and those are handled by that insurance company and that insurance company's counsel. But there's no reason we could not request them to provide us with information, so that those cases, if they settle, would show up on the report as well.
Thank you.
And that insurance, by the way, I assume it's been around for a long time. It allows the county to provide insurance to the independent fire companies, local fire rescue departments, so that they're also provided by insurance.
Thank you. clarifies it for me. Thank you. Thank you, Madam Chair.
So maybe what we can do is that when it comes to full council, Ms. McCartney Green, we can have that specific information about that insurance and the fire piece, and then we can incorporate that the full council.
Will do.
Thank you. Okay, wonderful. So next item.
And so the second amendment from the county attorney was altering section 20-2, which provides a county attorney the authority to settle claims up to $5,000. Specifically, the county attorney suggests that we should increase that maximum settle amount from the $5,000 to the $30,000, based on the notion that this was set back in the 1970s and does not take into consideration inflation or the consumer price index. I looked at other states to see what they were doing, and it varied. But there are states, just based on codified language, that every 3 or 5 years they look at inflation rates to see if it should increase. I'll be honest, I wasn't able to find anything internally here in Maryland and what we've done, or at least in the county. But with the notion of ranges, I think Mr. Hanson mentioned already, ranging as low as 5,000 or up to 30,000. It's just finding where that middle ground. Do we want to be on the high end of the 30,000, and or is there a middle ground as well? But either way, the amount set right now has not taken into consideration inflation or the consumer price index. So the decision point here is to decide whether or not to increasing that maximum settle amount to 30,000.
And are we interested also in including some language regarding just the regular alignment with inflation, et cetera? Is that something that we also would want to include?
Yes, Chair Navarro, just like I said, I looked at other states where they did include that. So I think that would be helpful to include that, where we're not stuck in this same phenomenon 30 years from now as well.
Okay, Councilmember Friedson.
Yeah, I appreciate it. I do think that we should find the right sweet spot. I mean, it seems, 30,000, my understanding that number is based on the Maryland District Court jurisdictional basis for civil cases. So I think if we're going to choose that number, we should just tie it specifically to that number. If that number changes, our number would change, and just say set at the amount, the Maryland District Court for civil cases, which is currently at 30,000. So, I think it gets confusing with inflation because, then you have, they're not round numbers, with inflation. And so I think in the interest of the public of knowing what that number is, it would be easier if we're going to tie it now to that number. We should just continue tying it to that number and move accordingly.
That sounds like a good option as well. So, okay, so is there consensus on first the $30,000, and then, as Councilmember Friedson also has indicated, without objection, we will do both of those things? Councilmember Jawanda.
Thank you. Just a question on this, I guess, to our council, or we are both our council, right? So just so this is very clear, the authority doesn't change the reporting requirement, right? This is just allowing you to within your own authority to take this step. Could you just explain what that means, if for the average person watching, like what does 5 to 30,000 mean, and just confirm that it would still be reported on this report?
Well, I would confirm it would still be reported on. Yeah. It would be included if the county attorney's office settled a matter for, let's say, $22,000. It would show up on that report.
Okay. Yeah. And this just changes your ability to have that discretion, because what would happen now? You only have 5,000. What would you have to do now if you wanted to settle for a higher amount? Just what's the current process?
I would have to go through the claims settlement committee. That is a committee set up in the self-insurance fund that includes representatives from all of the other insured entities. So it would be the county attorney, the county government representative, the Board of Education representative, the college representative, and so forth, including all the members. So it's a bit of a bureaucratic.
So it gives you some more flexibility.
It gives the county just, and to strike, for example, settling at the courthouse steps and at the district court would be helpful.
Right. Awesome. Thank you. Just wanted that to be clear. Thank you very much.
No problem. All right, Ms. Kern-Green.
Okay, moving on to OL had an amendment as well, and so I'm at number 8, just so everyone's keeping a track. So anticipates that the Bill 1921 will have a minimal impact on racial equity and social justice in the way that it's written now, but it could have a favorable impact, if it requires reporting of demographic data and settlements of claims and employees accused of misconduct. I do want to stick a point here because I did go into a lot more details in my addendum. So I'm happy to kind of transition to there as well, unless we want to talk about it here specifically. I want to be able to combine OLL's recommendation along with some of our advocates from Silver Spring Justice Coalition who also mentioned that as well. So I'm talking about it here because that's what's in the packet, but if I can, I'd like to just merge those together.
Yeah, I think that would be fine. So are we going to go by the addendum then?
Yes, yeah, we can all kind of turn to the addendum.
Okay,
And
great. Let's do that.
so I'll just start in succinct order with amendment number 1, and then when we get to the demographics part, I'll tie those in. So I'm on page 1 of the addendum. And so the amendment number 1 from the Silver Spring Justice Coalition was to require reports by the county attorney to the council and the county executive when a legal claim is filed against the county based on allegations of wrongdoing by a member of a law enforcement department. So as we've discussed, the Office of County Attorney already tracks reports and basic information when filed. That information is available on its website, and it just states the title, open date, department name, and case status. It's not clear whether or not SSJ was also talking about pre-file claims or ones that are not lawsuits. But I also invite a county attorney to talk about what the process is with dealing with just pre-file claims if they haven't aroused to a lawsuit, and if that's being tracked there, just for clarity on what is available and what's not.
Mr. Hanson.
Well, I'm sorry. I don't think I quite
specifically
understood
regarding
the question. Yeah. So what information do we know? Like the county attorney's office, once a claim is filed, just so everyone knows, the county attorney's office receives notices of claim that are filed by parties who believe they've been injured by the government. And that's required under the Maryland Local Government Tort Claims Act. And it's supposed to be filed within 1 year after the injury has occurred. But it's not all of the claims are captured by the Maryland Local Government Tort Claims Act. So, for example, a claim for violation of the federal Constitution or the Federal Civil Rights Act is not subject to the Maryland Tort Claims Act. And so a claimant doesn't have to always file with my office. And so the first time we may become aware of the claim is when we receive the lawsuit. And those claims generally set out, sometimes with specificity and sometimes just very bare bones, what the basis of the claim is. And sometimes they're relatively conclusory in nature. And again, as I said, sometimes they go into significant detail. So we do have information that precedes actual lawsuits in some cases. That doesn't necessarily mean that they mature into actual claims. Sometimes they just are not pursued for various reasons. But and in some cases, when we get a claim, we will, if we believe it has merit, we will try to resolve it before a lawsuit is filed. In which case, if that were to occur, it would appear on the report.
Okay, Councilmember Dwanda.
Thank you. So this suggested amendment, I think it's a good one in that it gets at the core of what the bill's about. It's, and I think council members, myself included, have often we don't want to be caught off guard and find out through the media or something when a claim is filed. And so, which is sometimes what has happened. And we have a couple bills trying to address that. So just based on what you're saying, Mr. Hansen, when the claim is filed, which is how I'm reading the amendment, you would be notified, right? If the county is a defendant, right?
Correct.
And so that's what I think this is getting at. If there's a way of having that immediately, whether, in whatever is appropriate as far as does it need to be closed session or whatever, this doesn't speak to that, but that we would be notified that claim, that lawsuit has been initiated. And I think some of that happens now, but I don't know if it's happening holistically. So I guess that's how I read this. And I do think this would be a good addition if that's something that you could easily do, again, narrow to the scope of what we've now narrowed these claims to. If there's a lawsuit filed, that we would be notified outside of the normal reporting at every year, right? Because that's the settlement, that's a separate issue. But this is related to when a lawsuit is actually filed.
You're really talking about a different report, that was separate report, because the bill requires reporting settlements where the county taxpayer money is being expended. Here we're talking about a universe of claims that no money has been expended and may never be expended.
Correct.
So it's really a different report. It's a second type of report.
Well, I'm not, and I don't think this suggests a report. It says, it actually says required reports. So it depends on how you interpret that. I am concerned about notification, so knowing, when that happens, when it's filed, realizing it might not go to fruition, but this is a narrow set of cases. Again, I don't know how many Federal Civil Rights, Tort Claims Act, employment discrimination we get, but something like that could be publicly known. We don't want to get caught off guard on and that's kind of, I think, what the goal is here. But you're right, it is different than the bill. I understand, but I'm just trying to interpret the amendment as I understand it. Maybe it's appropriate somewhere else, but I think, that I just wanted to flag that for colleagues and also make sure we were talking about the same thing.
So the issue of whether it is appropriate for this bill is just, I'm just kind of following the discussion here. Ms. McCartney-Green, do you believe that this would be appropriate for the scope of the bill to include this?
I do agree that this is a separate report. This is different in terms of not the settlement agreements that are occurring. This is kind of a pre-filed claims. And so it's hard to narrow it because of the different ways that they can go, right? Whether they're dismissed, whether they're moved forward. So I do believe that there might be more thought to this. If we're going to amend it and do it as a report, we may want to look at what are the different scenarios of how they can be dissolved prior to getting to a lawsuit. And to make sure we're capturing that, I would hate to put language now knowing that there's variations in doing that. So I'm happy to discuss that if we want to be able to do that with the lead sponsor. We would have to put the language in there because this would be a separate report. Agreed, there hasn't been any exchange of funds or through a settlement. So
right. So I think I'm referring more to the notion of whether there might be another bill that's making its way through the council right now where this would, fit within the scope. One of the things that we're always concerned about when we are discussing bills is, whether we can include amendments that are now within the scope of the bill and therefore not appropriate. So if we put a pin on this one, and then if you can take a look at this and see whether there are other bills making its way through the legislative process where this might be more appropriate according to the scope, so that we're not veering away from the the scope of the bill, and the public hearing was about this particular scope and all that. So why don't we do that? Let's put a pin on this one, and then we can come back to that when it's time to get to full council. Thank you. Okay. Excellent.
Agreed. And amendment number 2 really is focused on some of the legal claim as well, but it's also referring to tracking of data that were 5 years before. Right now, the OCA reports on self-insurance funds and non-self-insurance fund within the past 3 years. So this too, Chair Navarro, I would also recommend to put a pin here and to see if that's better suited in a different bill.
Okay, let's do that.
Okay, so amendment number 3, whether or not published information should include demographic data regarding the claimants and the employees accused of misconduct. This is consistent with OLL's recommendation, which we mentioned earlier. Council staff agrees with the proposed amendment. It's important for the county to collect demographic data on the claimants and the employees accused of misconduct. The report should include tracking of race, ethnicity, gender, age, disability information. Further, the demographic information should be collected post-settlement negotiations. I think this is very key. We're not doing this in the beginning nor during settlement negotiations. This is after the claim or lawsuit has been settled. And it must be voluntary. So, that this would not be something that would be required. The data would be helpful to collect to determine whether the county is using equitable fairness among all demographics. And it's an internal look on our measures, our performance measures. We're looking at racial equity and social justice and seeing what those measures are. Like I said, I would recommend this, post-settlement negotiations so that that doesn't involve and that it would be voluntary for a claimant to complete that.
Okay, I think that is very much in alignment with our racial equity and social justice law. So I think it would be important to include this. Councilmember Jawando.
Thank you. I just make a quick point. Absolutely. And it was so in alignment with the law that I didn't even include it specifically. So I thought that I understood it to be, like part of the ethos, but I appreciate the county attorneys and OLO and the community for pointing out that this is critical. So thank you.
I agree. Okay, great. Without objection, I think that we will adopt that. Mr. Hess, sorry.
I'm sorry.
Go ahead.
And I understand the sensitivity of this issue. I would just like to introduce a note of caution here. I completely agree with council staff, with Ludine, that this would have to be voluntary and after a settlement has been negotiated. Including not only from the claimant's perspective, but we don't necessarily have demographic information, and I don't know if this would include the employees' information as well. I was not clear about that. And I know that, I'm sure the collective, the unions would have something to say about that too as well, but so I just wanted some clarification on that, and then I have a comment I wanted to make as well.
So yes, it would include the claimant and employees. I think for a thorough process of collecting the information is to see both sides and to be able to collect those. And Mark, I know we did discuss that. It's not typical for your office to collect that information, and you're really deciding the merits of the case based on the facts. And this is why I mentioned that it would be post-settlement negotiations, but it would be for both, unless the council or the committee here decides, otherwise.
And it's voluntary. It's not the other piece to this. Right.
So the comment I wanted to make is that, and I'm looking at this through the lens of a lawyer who has seen a lot of discrimination cases over the years, and discrimination cases usually require showing a comparator. In other words, I've been treated differently because of my race. Someone else was treated better than I was, and they were a different race. But that means the two situations have to be comparable. And the note of caution is here that cases are very unique. They're so fact specific. The settlement value of a case really depends on a whole host of factors. Number one, is there liability? And sometimes liability is clear, sometimes it's not so clear, and so it's questionable. And if it's questionable, that has a value that plays into whether a case is, the settlement value of a case. Another thing that plays into it is the damage incurred by the claimant. So has the claimant been physically hurt? How serious was the physical injury? Is it permanent in nature? that has a huge impact on the value of the case. Then there are a whole host of other issues that come into play. Is the fact pattern such that the trier of fact, either a judge or jury, might be inflamed and say, "Oh my gosh, you know, I know that the plaintiff claims that they were only, that there was, a sprained arm or wrist, but what happened to them was awful, and the damages get inflated, and that also drives the settlement value of a case. How good a witness our employee will be, how good a witness the claimant will be, how believable they are. All of these things play into making every case unique. And you don't see a lot of repetition, at least in the cases once they get up to the county attorney level where there are actual cases filed. So the data we get, first of all, will be a relatively small number of people. There may be people who decline to give us the information. And then drawing in, I guess, what the caution is, drawing the inferences from that report will be, I don't think you can draw any inferences without understanding the unique characteristics of each of the cases. So that's the note of caution I want to throw out there.
Thank you. I really appreciate that. Okay. The next item, please.
Yes, the amendment number 4 and last amendment, SSJ wanted to know, clarify that the county will abide by recent judicial precedent prohibiting police misconduct settlements from including non-disclosure agreements. So council staff had just researched a little bit, and in the case of Overby versus the mayor of Baltimore, was a case where, and I'll give a little bit of factual background, but then just go into the logistics of it, where there was an individual who was engaged with police, and there was some abuse, and as a result of that, Mrs. Overby brought a case against wanted to settle with the Baltimore City. And in that settlement, the requirement was for her not to disclose some of the terms of that settlement. And it's very similar to a kind of a gag order where she was not allowed to mention some of the terms and the contents in the case. With that being said, Ms. Overby was approached by the media, and while her settlement was being approved by the city, disclosed information, and that was made public. As a result of that, the city came back and cut her settlement amount in half. It was around $67,000, and they reduced it in half. Ms. Overby and her attorneys filed a lawsuit, obviously that they're in violation of the payout, and as a result, this case went through the lower district court, and who ruled in favor of the city, and eventually Ms. Overby appealed. So now I'm talking about the U.S. Court of Appeals decision in the Fourth Circuit Court. And I really rushed through that, so I'm happy to fill in details if needed. But essentially what the court did, the Fourth Circuit Court said, was that the city's policy of including a non-disparaging clause, and that can also be a confidentiality clause. I've classified it as a non-disclosure clause in settlements with police misconduct claimants violated the First Amendment. So the court rejected that the city's claim that the non-disparaging clause in Overby's settlement agreement amounts to a waiver of a First Amendment right? That because she signed this settlement agreement, that she waived her right, knowingly and intelligently waived her right to the First Amendment. The court pushed back and said that's not true, that the settlement was unenforceable and that she can't waive her right to First Amendment. And further found that there's no serious doubt that the government has used its power to curb those efforts by using that clause. In essence, as a result of that, more recently in 2019, after the ruling, Baltimore City Council passed and enacted Council Bill 19-0409, and it was called the Transparency and Oversight in Claims and Litigation Act. With that, it prohibits the use of non-disclosure provisions in settlement agreements for specifically for police misconduct and unlawful claims filed against Baltimore City. And the law also now requires that the city law department to publish that web on the information about claims. So really the decision point here in putting a synopsis on it is the amendment is, whether or not the Bill 1921 will adopt a similar provision as Baltimore City did in terms of a non-disclosure agreement or prohibiting a settlement agreement where there's police misconduct to include a non-disclosure agreement. The court has, in this case and a few others, have looked at confidentiality clauses as unfavorable and a waiver of that First Amendment. So I'll pause here, but I did include very brief language of what it would kind of look like, and happy to broaden that if needed, but it would be Section 20-3, non-disclosure clause in police misconduct settlements is prohibited. An agreement to settle a claim or lawsuit involving a police misconduct or unlawful discrimination must not include a non-disclosure clause. So I'll leave that there for discussion and questions.
Okay, great. Councilmember Schwandel.
Thank you. I think this is a great amendment and obviously consistent with the ruling. The only question I had is there a reason to limit it to non-disclosures in a police case? But since this bill covers settlements of any, under the scope that the committee just narrowed it to, which could be non-police cases, I just think it might make sense to take the amendment, but just not have it be just specific to police. Is that Ms. Green?
Yeah, so I looked at the consistency of the court, and this was specifically in a lot of police misconduct cases where the public has an interest to know and want to know, especially the media, what happened, what were the facts. So it's narrowed in a sense of that was consistent with judicial precedent. Not that we can't open it up to all, but I'm very confident about police misconduct. If we want to looking at it broad, I will be honest, I want to do a little bit more research before I recommend that to the committee. But what I propose here is what I found to support from case law.
Well, maybe, so maybe then you could look into it between now and full council and see if there's any other case law or jurisdictions that have taken that step. But I think since you made that great suggestion to narrow the scope to civil rights claims, we've already narrowed it to a set of claims that do have a high public interest. So having the NDA prohibition, I think, would be appropriate, but happy to defer to obviously the committee's action, and then we can hopefully maybe take that up in full council.
I think we can put a pin on that as well. And then, as I said, you can look into, how it aligns with what we've already done in terms of narrowing what it applies to and see if that is appropriate or not. I think at the very least, it seems to me, as I saw nodding, the committee would be interested in the police misconduct piece, but or unlawful discrimination. I think at the very least that is something that we're interested in. But if you can take a look at making sure that perhaps is a little broader, but within the scope of what we narrowed, I mean, that's another one that we can look at. Yeah, before we get to full council.
Sounds good. Will do.
And also, I just wanted to also point out that in terms of those other two amendments that were more appropriate for a different type of bill, if you could also let us know, obviously, as soon as possible, where that might be more appropriate, et cetera, so that we don't just leave it open-ended, but that folks know that that the reason why we're not including it here is just because of the scope of the bill. Okay, all right. Anything else, Ms. Green?
No, I thank you all for your time and appreciate going through each amendment.
Well, thank you. And thanks to, of course, Mr. Hanson, Mr. Markov is here. I think with that, is there a motion to adopt the bill as amended?
So moved.
Okay,
So
well,
second.
moved and seconded because of every second. Cats, all those in favor, please raise your hand. We raised our hand, and then we will go ahead and submit this to full council and take up those other items that that we would be looking at further exploration as well.
Thank you for letting me join, everybody. Appreciate it.
Thank you for participating. And with that, we're going to move on to our second item, which is additions to the Office of Zoning and Administrative Hearings Comprehensive Fee Schedule. And we have here she is, Ms. Nadeau with us to walk us through this particular item.
Good morning, council members. So this is a proposed amendment to the Office of Zoning and Administrative Hearings fee schedule. What it does is it adds an $8,200 application fee for solar collection systems. So as a bit of background, as I'm sure you all remember, on February 23rd, 2021, the County Council adopted ZTA 2001, which established standards for solar collection systems in the Ag Reserve. And it decided on conditional use approval for solar facilities that are larger than 200% of on-site energy use. And so before it was site plan approval, and now those go through the conditional use process. And that ordinance became effective on March 15th, 2021. Because now applicants need to go to OZA, a fee needs to be established so they can actually go through that application process. So OZA and planning worked together to establish this fee. It's a flat fee, and flat fees are usually based on the estimated time that's needed for both review based on the staff's hourly rate. The proposal that's put forward before you today is to use the same fee as agricultural processing. So I can quickly give the definition of agricultural processing is any operation that transforms, packages, sorts, or grades farm products into goods used for intermediate or final consumption, including goods for non-food use, such as the products of forestry. It includes milk plant, grain elevator, and mulch or compost production and manufacturing, but does not include a slaughterhouse. So I know that doesn't seem extremely similar to a solar collection system on its face, but the reason it's similar is because those fees are based on review time. The sites are actually very similar in size. They're both solar farms, and agricultural processing can both be very large sites, particularly in the AR zone. And actually for solar collection systems, it might even be a bit larger because we're expecting the most contested issue to be the screening and the buffering around the perimeter of the property. So 8,200 is actually probably on the shorter end of review time for the solar collection system. I actually have Lynn Robeson-Hannon here from the Office of Zoning and Administrative Hearings, as well as Robert Cronenberg and Christina Sorrento from Planning. I can turn it over to Ms. Robeson if the committee has questions.
Yeah, anything that Ms. Robinson or Mr. Cronenberg or Ms. Sorrento want to add, please do so. Let's start with Ms. Robinson.
Thank you, and good morning, everyone. The reason that we base fees on hourly rate, the cost to process based on hourly rates of staff, and whenever we have a new conditional use, we really don't know in advance what the review times are going to be. So we do try to base it on a similar conditional use. And as Ms. Nadeau said, the reason we felt this was comparable to the agricultural processing is that they're both large properties. They typically are large properties, and screening is one of the major issues. I do think it's probably on the low side, just because the area of screening many times in the agricultural processing use is actually smaller. But that's the best comparable we could come up with without having actually reviewed the solar farm conditional use yet. And I'd be happy to answer any questions.
Okay, thank you. I don't see any questions from my colleagues. Anything else, Mr. Cronenberg or Ms. Sorrento?
Good morning. Thank you. And thank you for letting us participate today. As Ms. Robeson said, we did look at the size of solar collection facilities that we would be getting applications for in the AR zone and felt like that would be comparable to fit them in the same category as noted. We also looked at other different types of fee structures, a tiered structure that would that would focus on the size of the property and the size of the collection facility. But in the end, the type of review that would be done would be very similar. And I think the focus would be very similar as well, with landscaping and buffering as probably the primary piece of review that we would be doing for any type of the application that came in. So we feel comfortable with the fee that was selected and the based on the $8,200 and the similar category. So thank you.
Thank you. Any questions or comments from my colleagues? Councilmember Katz?
Yeah, thank you very much, Madam Chair. You know, we literally struggled with trying to figure out what's a way that we can get solar in the Ag Reserve and that it would work for all. Is there any solar now that you've charged a fee for outside of the Ag Reserve? Do you have any background on any of that?
We have through site plan reviews, but not a conditional use. So the site plan review would have gone through a much more intensive process than it would through the current one that's being recommended. And it involves we don't have a kind of a site plan light process for this. So we felt like, that's one of the reasons we didn't go with a tiered structure, because our site plan process is really geared towards number of units or square footage that are typically assessed with each application. So the short answer is no, we don't have any other ones other than through site plan.
And candidly, my concern is, and I don't know whether $8,200 is a lot of money for this or, very, very little money for something like this, but I wouldn't want it not to happen because of the fee. But, I think we have to be fair on this, and I think that's what you're certainly trying to do. So I guess I'm okay with it, but if we could get the first one to be free, I would be okay with that too, so that we could actually get one done. So anyhow, thank you.
I would say that the amount that's being charged for our review is probably pretty close to being free.
Okay. All right.
I have to second that. OZA's total budget is about, all our fees are probably not representative of the actual cost. OZA's total budget is about $500,000, and we take in about 90,000 in fee revenues every year. Technically, the council could subsidize the fee if they wanted, but that would raise issues in comparison with other conditional uses and possibly open up to unequal treatment. So I think, this is a relatively low amount compared to the actual cost of filing.
All right. Any other questions from my colleagues? Although the agenda does just state discussion, I believe we do have to act, correct? So, okay. Is there motion?
I'll move approval.
All right. All those in favor, please raise your hand. So we do approve the recommendation stated in the packet. Okay, everyone. Well, thank you so much for being here and for your great work. And with that, I believe this committee session is over and we're adjourned.